2 chapters are on corporations. Right? We started off last class talking about the different ways in which business entities are formed, and we started off with the most simple sole proprietorships. We moved on to general partnerships, and we talked about limited partnerships. You would think we would talk about LLCs next, but no, because that's just not how the chronology of the chapters are in this textbook. We first talk about corporations, and then next class we talk about LLCs. Okay, so it's not like we've forgotten about them. We will come back to them, but we'll spend about 3 chapters talking about corporations. The first chapter just on a simple chapter on corporate formation. The second chapter that we'll do today is on corporate governance, another important chapter. They go together. Next class, I hope I have the chapter numbers memorized by now. I think we're going to talk about corporate acquisitions and tender offers and mergers and so on, and then we'll talk about limited liability companies. Everyone with me? Now, I wonder if people are out because of the holiday. I mean, we all know that, you know, Good Friday, Easter, Sunday, and all of that is not something that the college overlaps with their spring break on, but that might explain why we don't have as many people as we do usually, but we'll get going. Thank you for those of you that are here. All right. Corporations. Love them, hate them. They are a business entity. And, you know, we talk a lot about, you know, I was just on my way in and I was listening to the radio, and obviously there's a lot of talk about the laws in Indiana and Arkansas, and you know, and the reason I bring them up is corporations responding to those laws, right? The Big Four college basketball, I want to say, right? Championship is happening in Indiana. So, you know, I mean, obviously they're looking to attract a lot of corporate sponsors and so on. So just off the cuff, you know, you hear like Walmart, you know, our favorite company, actually taking a stand and saying, no, I mean, we're going to restrict our business activities, Apple, and so on. And they likened it to, believe it or not, there was a great story that, you know, way back, 1964, when Dr. King won the Nobel Peace Prize, there was a a dinner that was being held in Atlanta. And, you know, I mean, imagine, this is 1964, this is at the height of Civil Rights Act and so on and so forth. And they couldn't attract any local businesses to come to the dinner. I mean, it was would have been a great embarrassment to the city and so on. So Coca-Cola back then, and there's all these stories about Coca-Cola taking a pioneering role, and the CEO then of Coca-Cola took a stand and said, you know, we'll move our corporate headquarters out of Atlanta. We will not do business in a city that doesn't believe in, you know, tolerance and so on and so forth. Obviously, you know, the racial segregation back in the day, that, you know, we're talking now 60 years ago. But, you know, so there was this great, you know, this is just like 10 minutes of listening to this to this speech and so on. And the good news is that, you know, businesses rallied and this was a huge success and so on. But they sort of likened it to that. And the reason I kind of bring it up with our corporation chapter is, you know, we'll talk about corporate activism and things like that. Do corporations have a role? You know, you know, we'll talk a lot about today, what's the role of corporations? Well, to increase shareholder value and so on and so forth. But is there a role for corporations as, I mean, if the Supreme Court says they're citizens, right, as corporate citizens to take a stand against issues, you know, issues that relate to, you know, I mean, 60 years later, we're talking about laws that are, you know, again, perhaps discriminatory, and, you know, and not to say that religious freedoms do not have a place in society, but how do you balance those two, right? I mean, that would have been a great topic too for the topics that you guys are doing. We'll consider that, yes. Say that one more time. Sure. 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 Sure, absolutely. So are you talking about have corporations?
You said, like, should they be treated like because they are like a person?
Well, I was actually making a sarcastic remark there. I was being quite sarcastic about, but the reason, no, right? I mean, I wasn't, you know, and I'm not trying not to take stance because people, but that's the Supreme Court said corporations give as much money as you want to political candidates, right? So I'm not saying I agree with that decision. I think the vast majority of people do not agree. So I was sarcastically saying, if you can't have it both ways, right? You can't be like go ahead. Right.
Then the corporations come in and they have it overturned.
Well, because of, yeah. I mean, I think that's Right. I mean, I think that's a huge issue. Most of us, and it's and I feel like I've opened up a Pandora's box because you're right. I mean, it's sort of this notion of, yes, we're a democracy, and yes, it's, we elect our legislators and so on. But in the end, if you really dig deep into how this democracy of ours works, I mean, they're constantly looking to raise money to get reelected, which of course is the way our system works. But who do they raise the most money from? Corporate donors and so on. And how do you do that? I mean, obviously you walk a very thin line about whether or not, once you get back into office, what do you owe those large corporations that donated a lot to you and are going to, I mean, Congress people run for re-election every 2 years. And the big joke is, right, that, as soon as they get elected, they're already, that's just the nature of the system. And I'm not judging anyone, it's just the way. And corporations, good or bad, have a role in that. And some of that, I mean, today I'm actually highlighting a good that corporations do in actually taking a social stand. But right, there's the opposite side too. But I mean, I think that's something that is such a long discussion about where has our democracy gone. In some ways, and is there any way to sort of halt that and kind of bring it back to more of a balance? But anyway, lots of good issues to talk about. But we're going to talk about sort of more the routine issues. How do you set up a corporation? Who are the players? What are the different? That's what this chapter is about. But rest assured, we'll talk about some of the more interesting issues as well. So, what is a corporation? It's a made-up, fictitious, legal entity that the law recognizes and gives rights to, right? And it's created how? It's created according to statutory requirements. And when I say statutory requirements, I once again mean based on a corporation incorporating under a state's law. Right? So when we talk about partnerships, LLCs, any of these entities, including corporations, they have to pick a state to incorporate in. So when I talk about statutory requirements here, I'm really talking about state requirements. And we talked about finance, we'll talk a lot more about financing the corporation and so on, but corporate owners are referred to as shareholders, right? That should come as no surprise to any of us. In a partnership, the owners of the business are referred to as partners. In a corporation, the owners of the business are referred to as shareholders, and it's the shareholders, as we'll see, that actually elect those people that set the policy for the corporation, referred to as the board of directors. So we'll talk about corporate governance in the next chapter, but this is just sort of an introductory chapter to get us familiar with the corporate entity. And again, I sort of get ahead of myself. Corporation codes, again, are state statutes that, once again, tell entities how to form, how to operate, how to dissolve a corporation. What are the necessary filings in order to get recognized as a corporation? Loaded title, right? The corporation is a legal person, right? It's an entity. It's a piece of paper behind which, individuals stand. But yes, the law recognizes this legal entity, which means what? It has certain business rights. For example, a corporation can sue, XYZ corporation can sue another corporation or be sued because it's a distinct legal entity, unlike a sole proprietorship that we talked about. There is indeed a difference between those who own a corporation, those who run a corporation, and the actual entity itself. It can enter into contracts, it can hold property, and as we know, to the extent that the corporation engages in fraud or other Securities Act violations or things like that, it can be found to be both criminally or civilly, meaning liable for damages and so on and so forth. And you say, well, how does a corporate entity get criminally liable? Does the piece of paper go to jail? No, of course not. But it means that in the right set of circumstances where there has been egregious sort of criminal behavior, those running the corporations have been found to be criminally liable for criminal fines and potentially liable for prison sentences, as we've seen not too long ago when we talked about things like Enron and Tyco and all of these companies that engaged in massive securities fraud. So what are some of the characteristics of a corporation? How are corporations perhaps somewhat different than some of the other business entities that we've talked about and will talk about? Well, corporations ownerships, as we said, is vested in shareholders, and shareholders own a piece of the business, and we refer to that as shares, right? So to the extent that we're talking about large publicly held corporations, we know that the shares of those corporations are actually traded freely on a stock market. So when we talk about, partnerships and LLCs and, people sort of owning stakes in those types of businesses, it is not as easy to sell off or purchase an interest in that business, whereas, of course, in a corporation, to the extent that the corporation has shares, it is somewhat easier to trade interest, meaning sell or buy shares in a corporation. So that's a characteristic of corporations that is somewhat different than other business entity types. The second bullet here talks about perpetual existence. What does the word perpetual mean? Continuous, ongoing, without a definitive end. I sort of argue with whether or not this is really a characteristic for a corporation or any other type of business, right? I mean, yeah, corporations have perpetual existence, but so can an LLC, so can a partnership, right? It is possible that sometimes you set up a business with a definitive end date, but typically not. We don't say, well, I'm forming a business in 2015 and I'm going to end in 2020 because I'm going to become a multi-billionaire and that'll be the end of it. No, we set a business date into perpetuity anyway. But we know that any business can be terminated. For instance, we'll talk about termination of any business type. One could be voluntary termination, meaning the owners, shareholders no longer want to run a business together, or they want to change the type of business, or they want to enter into another type of business, they want to end this corporation. Or we'll see that sometimes the termination of a business is not voluntary, it's involuntary, right? Where the regulators and so on come in and actually force the dissolution of a business because of fraud or things like that. So perpetual existence, yes, it's true that that applies to a corporation, but as I said, I think that applies to any type of business entity unless you set a definite date on which something is going to end, which is not typical. And what else? And I think this is kind of significant when we're talking about corporations, particularly large corporations, in the sense that they do have what we refer to as a very defined centralized management, right? It is clear within the corporate structure that there are these players that play defined roles, and that's what the next chapter is all about, right? We know that in a large, I shouldn't say a large corporation, I would say a corporation of some reasonable size is going to be governed by a board of directors, and we know that the board, we'll talk much more about what the board's role is, it's really a board of defining policy. What is the direction for the corporation? And we know that shareholders as owners are going to have what we expect a lot of owners of businesses want to have, and that is limited liability, right? We talked about the struggles of sole proprietors, thank you. I want to call them sole practitioners, sorry. Sole proprietors and general partners suffer from not having any shield of liability between themselves as owners and, the business. Well, for the most part, other than, cases of fraud and so on, shareholders of a business do not have personal stake, meaning, to the extent that a corporation is sued and the assets of the corporation are not enough to satisfy the creditors or the plaintiffs, shareholders themselves typically are not liable for that, and that is the limited liability protection. And that, again, is a characteristic of the corporation. So real quickly, this is sort of a very summary slide, and it's really what Chapter 37 is all about, corporate governance. Who are the board of directors? Well, it's a panel of people. It's any number of people that basically set the decision, the direction for the corporation. We know also that, as we've already said, shareholders actually own the business. They are not personally liable for debts and obligations. We'll talk much more about shareholders next chapter as well. And then, a group of people that we haven't talked about are corporate officers. Who are corporate officers? Well, they work for the corporation. They're sort of the high-level employees of the corporation that are appointed by the board of directors that actually run the corporation. So, typically we think of CEO, CFO, CIO, treasurer, secretary, whatever, these titles that make up the upper tier management of a corporation. Everyone with me so far? Questions? We've seen this diagram now a gazillion times that talks about liability, right? And, we just sort of change names of owners, it seems, and we sort of just depict, well, what happens if a bunch of owners, shareholders, put money into a corporation, and let's just say, real easy, 4 shareholders, they invest 25% each, and they own 100% of this corporation, but they wind up owing money to a third party, and somehow the business runs amok, and there isn't enough money to pay off the third party. What happens? Well, the shareholders' liability is limited to their capital contribution, meaning what they invested into the business may be gone. However, there is no personal liability to this third party for debts and obligations because it is a corporate structure, and a corporate structure, is not, the business owner is not the same as the corporate entity. And a case that kind of brings that out is this Menendez case out of Louisiana, Court of Appeals of Louisiana, 2008 case. A pretty easy case to understand, sad set of facts. What happened? Yes?
Drove in this and driving down the highway. Just got in a car accident with a guy on the He had found to be drunk. So they found out what bar he was drinking at.
Was he overage, underage?
He was underage, 19.
Yeah. Right, and that was sort of the distinguishing factor. It was a corporate entity, but it was one shareholder.
Yeah, he was
right.
the only shareholder in the
Correct.
corporation.
So they sued the corporation, but they also sued the individual owner, shareholder of that corporation personally.
So it went to court, and they ruled that that he has, because of the corporation laws stating that there's limited liability for shareholders.
Correct.
He was once he showed paperwork, the articles of corporation.
Correct.
They said that he could no longer sue. That he fell under being a shareholder, and you could no longer sue him.
Right. And that's exactly right. I mean, this was a case where, and this is typically what happens when you bring a lawsuit. You try to name everyone who you think could be a potential defendant, right? So here they named the car insurance company, they named the corporation, and they named the individual shareholder of that corporation. And before they even decide whether or not, and this case was not about, the case in the book was not about whether or not even the corporation is liable. There'll be a trial on that, maybe they'll settle, whatever. But the issue was whether or not the owner shareholder should even be named as a defendant. And he moved in court to say, I should not be. And before the case could even go to trial, the court rightfully agreed and said, even if, and the point here to take away from this case is, we think about corporations as having a bunch of different shareholders, right? But most state laws, including Louisiana, allow one person to be the sole shareholder, right? And that's what happened here, right? And, the court said, well, that in and of itself is not evidence that there was something, something fraudulent, right? The fact is the corporate entity is still separate from the owner shareholder. The owner shareholder is not personally liable, and to the extent that there is liability, it could go to the corporation. Maybe the corporation has insurance or whatever. Yes, serving an underage person and maybe engaging in negligence could make the entity liable. However, the individual owner, even if they're a sole shareholder, is not liable because we're going to respect the corporate incorporation, and we're going to respect limited liability of shareholders, even if we're talking about a sole shareholder. Okay, let's talk definitions. Boring in some respects, but necessary, because unless we understand terminology, we're not going to understand the other legal rules, right? And some of you might say, I know this stuff. But be careful, because when we use words like public corporation, most people sometimes think, I know I have the slide up already, but when you think public corporation, most people would immediately think, oh, she's talking Apple, she's talking Google. No, I'm not saying publicly held corporation, I'm saying public corporation, and there's a difference. So public versus private. A public corporation is actually a governmental, a type of corporation. It is, it's sort of the municipal, it's your town water company, it's your school board district, it's something like that. So a public corporation is a corporation formed to meet a specific governmental or political purpose. So don't confuse public with publicly held corporation. Okay, public, quasi-governmental, versus private, a corporation formed to conduct privately owned business. And one of the examples that I can give of a public corporation, in addition to things like your local school board, your local water company, are think transportation. Think about the Port Authority, right? That is a quasi-governmental agency. Well, utility. Right? Utilities are not governmental, but they're, they are a public utility, right? They're not but again, if they're responsible to shareholders as utilities, they may be private as well. But public, I'm talking about some quasi-governmental, charitable kind of interest. The metropolitan, MTA, New Jersey Transit. So again, that is a public corporation, but anywhere where you're talking about a corporation that is designed to make a profit for its shareholders, whether it's big or small, is a private corporation. Okay? Public versus private. Yes?
What's the word that you use, quasi?
Quasi means, quasi means sort of. Sort of. So, quasi-governmental means it's sort of governmental, even though it's run a bit more independently. QUASI. So Port Authority is one of those creatures. Actually, my first job out of law school was working for the Port Authority, and I was flabbergasted at how huge this, they own, back when the World Trade Center was still standing, World Trade Center, all three airports, the path, huge multi-billion-dollar enterprise, run by, with influence of both New York and New Jersey. What's that? It's in New York, One World Trade Center still is. In fact, they own One World Trade Center. The Port Authority, which most of us, when we're growing up, are thinking about as the bus terminal in 42nd Street. Well, it's much more, and again, they've had their political issues and so on. And I use the word quasi because the government appoints the executive director and so on and so forth, but they run independently. So that's what I mean by quasi. Sort of governmental, but have a lot of independence, and not to get political about it, they've been in the news a lot for some of that abuse of independence. So anyway, we can go on and on. So public versus private. What else? Profit versus not-for-profit. Right? We talk about not-for-profit corporations and for-profit corporations. Well, most businesses, unless they fit into what a not-for-profit can be, for example, are you a charitable organization? Are you a religious order? Are you some sort of a scientific organization that is set up for research or something like that? Because the law doesn't recognize other forms as being not-for-profit. And not-for-profit means not-for-profit, that you're running, the purpose for running this organization is not to turn over a profit for shareholders, it is to reach some specific purpose. To run a church, to run the Red Cross, to run some sort of a charity or things like that. So those are not-for-profits versus everything else. Any business that is set up to run a profit. And obviously, a business doesn't have to be profitable. We know a lot of businesses run at a loss. That still means they are a for-profit business because their objective is to make a profit and then to distribute that profit to their owners, to their shareholders, right? For-profit versus not-for-profit. And you're set up as either public or private, a profit corporation, for-profit corporation, or a not-for-profit corporation. And we know, of course, the big thing with not-for-profit corporations, and we often refer to them as 501c entities, because what is a 501c? Where does that come from? Yeah, it's the tax code section that basically makes them tax exempt under federal law, right? So that's what I'm talking about when I say not-for-profit. Other distinctions among corporations is whether or not now we get into publicly held versus closely held, right? So we talked about public versus private. This is publicly held versus closely held. Well, what does that mean? Publicly held corporation is a corporation with a lot of shareholders. You know, it's the Apples, it's the Yahoos, it's the Amazons, it's the, I don't know, name your favorite corporation, right? That is owned by a lot of shareholders, and the shares of which are traded on a on a national securities market. You know, whether it's the NASDAQ or the New York Stock Exchange or whatever the case might be. That's a type of corporation, a publicly held corporation, not a closely held corporation. What is a closely held corporation? A closely held corporation is a corporation that doesn't have a lot of shareholders. The shares of which are not traded on a major enterprise. And sometimes very large corporations choose to stay private because they're big family-owned businesses. They're very few shareholders, and they want to keep it that way. You know, I was struck a while ago, you know, sometimes these news stories comes to mind. I was watching, I don't know, 2 or 3 years ago. I'm a big hot sauce lover. I love hot sauces of every kind, every variety. And then they had a story on 60 Minutes on Tabasco. You know, you can try all the hot sauces in the world. You got to come back to the good old Tabasco. There's just something about it. And, you know, there's such an interesting story about how, you know, over the years, it's been a family-owned business, and how particular it is in terms of how the chili peppers are grown. And it was just so fascinating, and I've got even more respect for the good old Tabasco. But, you know, so most of us, when we think about, wow, that's got to be a big company. No, it doesn't have to be. I mean, you know, corporations that we think of as being a household name can choose to remain a closely held corporation, meaning it's very few shareholders, and they don't want their shares traded on a big market, that it's going to be a few shareholders that are perhaps, you know, you see the word buy and sell agreements, we'll come back to what they are. It basically means that for any owner to sell their shares, they might need the approval of the other shareholders. They want to keep it closely held. They want to keep their business with certain standards and so on and so forth. So that's the difference between publicly held and closely held. A professional corporation, you know, ever see like a business name that at the end of it has a PC at the end? What does the PC stand for? Not politically correct in this case. It stands for a professional corporation. And if you think about the word professional, then the only people that can form a professional corporation are a bunch of professionals. Surprise, surprise, you know. So, you know, yeah, I mean, you're talking about lawyers, doctors, any kind of professionals. And here, you know, we often refer to the owners of this corporation instead of shareholders as members of a professional corporation. And here, it's oftentimes state law that dictates what they can or cannot do. The problem here is when you think about lawyers and doctors, providing services to the general public, one thing that comes to mind is liability, right? If you set up a business as a corporation, say there's no shield, you know, I mean, well, what if that business commits liability that runs into the millions of dollars? Then how does the plaintiff get recovery? And oftentimes what professional corporations do is make members liable and require them to carry a good amount of insurance to allow them to use a corporate structure, if you will. No, it's not either or. I'm sorry, it is either or. It's not like you're going to be personally liable and, you know. So again, state laws vary a little bit on the ins and outs of who can be a PC and what the requirements are. So yeah, I mean, if they're you know, you're going to be very careful. I mean, partnerships are not going to give you, you know, if you set up, you know, a dental office or a doctor's office as a partnership as general partners, not such a great thing. You know, you're not protecting the individual owners from personal liability. If professional corporations in your state allow you to get rid of personal liability by purchasing insurance, malpractice insurance at a high enough level, you will. and so on. So here, the reason why professionals are treated a little bit differently is because of the unique nature of services that they provide to the public and the public policy to try to make sure that there is something to go after if there is some catastrophic type of malpractice that is committed. And it is possible they may be liable for malpractice of others, but again, you manage that through malpractice insurance. And you often see physicians in particular saying malpractice rates are off through the roof and so on and so forth. And again, this is one of the considerations of certain types of professions. All right. Public, private, profit, not-for-profit, publicly held, closely held, PCs, all right? So there's a bunch of terminology that we need to understand. And again, we want to talk about corporations. Someone's laughing at the word alien? Okay, we'll get to that. I know, it's funny. It's not from Mars. You took away my joke. All right, so in order to incorporate a entity called a corporation, you got to pick a state. And we all know that large, publicly held corporations flock to one particular state, Delaware. And we'll talk a little bit about why Delaware in just a minute, but you got to pick a state, right? And the state in which you are incorporated, where you file your papers, where you disclose certain information to the state and so on, is the state in which the corporation is domestic, right? You can incorporate here in the lovely state of New Jersey, but we all know that businesses are conducted by a corporation or across state lines, so you may have to file papers in other states in which you do business, enter into contracts, sell products, and so on and so forth. You have to file some minimal paper there as well. You're going to be considered foreign in those other 49 states in which you choose to do business. But we also welcome corporations incorporated in other countries when we recognize them. That's where the word foreign is already taken up, so we have to come up with another name, and the word alien is what is used to describe a corporation that is doing business in the United States, but it has been incorporated in another country. And even those corporations can sell shares on the stock market, but it's a little bit different in terms of how they sell their shares and so on. But they are referred to, it's not a word that's commonly used, but they're quote unquote alien corporations here in the United States. All right. Remember, in order to set up a business, you still have to do it under state law, and you have to, again, select a state in which you want to be incorporated in. So a corporation can only be incorporated in one state, right? You can't pick multiple states. You have to pick one. You can be foreign in every other. It's not like you can't do business in any other state. You can, but you have to file incorporation papers only in one state. You can qualify to do business anywhere else. And the same kind of considerations when you set up a business name for any type of business, whether it's an limited partnership, LLC, but particularly a corporation. You've got to pay attention to what the state, what the requirements are. A lot of states will say if you are a corporation, then use a word that to the public would identify you as that, either the word corporation. Company is kind of funny because with limited liability company, you don't want confusion there, but a lot of places will have INC, Inc. Well, incorporation only happens with corporation. So yeah, you may have to carry that, Jane Smith Doe, Inc. All right, I know that's a corporation, right? But you got to be careful. You can't trademark, you can't be infringing on someone's intellectual property. You can't use a name that's already been trademarked or is too similar to that. Same thing, if you're setting up a new business, you want to make sure today particularly, not only do you care about a name, you care about, can I register that name? Can I get a .com? And you got to be, you got to sort of keep that in consideration because of business recognition and so on and so forth, and social media. If you can't even get your domain name registered because someone else owns it for legitimate business purposes, you want to think about that as well. So, same considerations that any other business type would have. We talked about businesses that are not as sophisticated, right? Partners and sole proprietors and so on and so forth. Not a big deal. You sort of have an easier time coming into and forming a business. But a corporation, even if it's not a huge corporation, has more formality, right? Just has a lot more to do in order to set up as that kind of business type. And obviously, we're talking about business law, so we're going to have to name everybody by some name that, there's more terminology that we need to remember. That's just the torture we have to go through. The party or the parties, individuals that actually file the articles of incorporation with the state are referred to as, get this, incorporators. The people that are responsible for incorporating a corporation that actually sign, and could be more than one person, are referred to as incorporators. They actually sign the paperwork to file the articles of incorporation with the state. But no, it doesn't end there. We have to use yet another name, promoters. Promoters are people that may or may not have actually signed the articles of incorporation, but these are the individuals that actually set up and organize the business. You don't immediately just snap your fingers and say, we're a corporate entity, we have an office, we've hired employees, we've entered into contracts. No, there's legwork that happens beforehand. Right? So, if you're setting up a business, you're going to hire people, where are you going to operate from? You need office space. You may have to buy a building. You may have to rent space. You may have to lease equipment, right? You're signing contracts. You're setting it up. Who are you when you negotiate and enter into contracts and you are the initial people, the initial investors in a business? You are the promoters. That's the legal name for them. And we'll talk about what happens to their liability in just a second. So everyone clear how an incorporator and a promoter, although they may be the same people, are slightly different. An incorporator is someone who only signs an articles of incorporation. A promoter is someone that actually is organizing and setting up the business, and they can be one and the same. It's not like you have to have different people doing it, but their legal duties, their legal names are somewhat different. I don't know about you, but I always think about liability. If I signed a contract, boy, I'm worried. If I guarantee a debt, I'm worried. What is my liability? And I can go on and on about how corporations have limited liability, but think about it. Before a corporation is formed, you're doing things as a promoter. Now the corporation, just pick a date. Between January to June, you're doing all of this stuff to start the business. July 1st, you file the articles of incorporation, and now you're moving forward. But what about my liability as a promoter between January to June? The entity wasn't even incorporated, right? How do I or my fellow promoters get assurance that we can't be sued personally for things that happened between January or June? That's what the slide is about, promoters' liability for things that happened pre-incorporation. Look, it's possible that a corporation can never come into existence. You do everything. You try to raise money, you try to get investors, and at the end of the day, it fizzles. Promoters will have personal liability, right? Corporation never got formed, so if they now want out of the contract for the 3-year lease that they signed on office space, right? They've got personal liability there. So these are things to think about. But let's say it's a happy case, and the corporation actually does form on July 1st in my example. The corporation is only liable on a promoter's contract if it agrees to it after the fact, right? Will the corporation accept the liability for things that were done between January or June? And you might say, well, who decides that? What's that? Well, no, do you write it into the contract? Well, no, let's say you didn't. Let's say, the contract was, let me just pick office space, right? We signed a 3-year lease on June 30th with some, right here on Washington Square Park or something for 1 floor. July 1st, it's incorporated, but the contract is under my name. I want the corporation to take liability for it. It's not my lease, it's the corporation's lease. It's just that we weren't incorporated at the time. Well, the corporation has to agree, but who runs the corporation? The board of directors, the officers, and so on. So as we'll see when we talk a little bit more as we get going, is that one of the things that corporations do once they become incorporated is they actually, because it's the same people, will agree that it's the corporate entity that is responsible. But here's the thing. Corporation may agree to be bound by the promoter's contract, but, and you may have made a very good point there, but if I'm the landlord of One Washington Park, I've only signed an agreement with you. I haven't signed an agreement with the contract. So one of the things that you negotiate, and this is above and beyond really what we need to remember, is you negotiate something called novation. This is why, for those of you that want to go to law school and really sort of understand a lot of these intricacies, novation. So you sort of say, hey, you know, I, Joe Smith, am signing the contract, but the corporate entity, I'm doing it on behalf of the corporate entity that hasn't come into existence yet. We're going to file our papers. We're going to negotiate a novation clause, which means that the landlord agrees that once the corporation agrees to take over the lease, the landlord will absolve the individuals and will only have a contract with the corporation. That's what's called novation. That's a lot more detailed than I will say. Do you remember the word novation on an exam? You've seen from my exams, I'm more high level. I do want you to know who a promoter is and incorporators, but I do want to explain that there's a lot of detail here. But I do want to teach something that may or may not pop up on your CPA exam, and when you're studying, you might just sort of say, what was novation again? Well, novation is this clause that the parties agree to where a third party will agree to release the promoter from liability for a contract that was signed pre-incorporation. Jeanette, did you have a question? Right. Correct. So when we say the promoters usually have liability, right, they will have that liability unless the corporation assumes that liability, which I will tell you typically is the case, right? Okay. Well, yeah, personal guarantee comes in, we've talked a lot about it, is when you take out a loan or credit. It's an arrangement where someone signs on as a guarantor or as a surety. That's what it means to give a personal guarantee. It's a credit situation. Sure. Good question. Right. Yes. So the question is, well, how does a personal guarantee come up? If you're saying that someone is not personally liable, well, if you sign a credit arrangement, a loan arrangement, and you sign as a guarantor or surety or give a personal guarantee, yes, that will make you personally liable. But if a corporation takes out a debt and the CEO signs as John Smith CEO, they have not signed personally. They've signed in their corporate capacity, and only the corporation is liable. Okay. Articles of incorporation, we've already talked about those. These are the filing papers. Pick a state, file the papers, basic governing document of a corporation. How do you do it? You file these papers with the Secretary of State. What kind of general information? You got to name the corporation. How many shares are authorized? And you pick a number, and we'll talk about how that works. And this is true. It's not going to be true of a not-for-profit, but it is going to be true of for-profit corporations, whether they're sold on the public exchanges or not. Name a registered agent. Everyone familiar with what that term means, a registered agent? This is naming someone where or place where someone can sue you. Corporate offices, where if someone has, because remember, you're a fictitious legal entity. If I'm going to sue you, I need to know, where do I come? Where do I file these papers? Where do I serve legal papers and so on? And it's possible that the Articles of Incorporation can say that it's for a limited time, but as we said, most corporations are perpetual in existence. What is the purpose? What are the limitations? I mean, if you want to put any on your corporate operations, right? So there's some general information that has to be in the Articles of Incorporation. And again, once you file these articles and you want to change certain things, you want to authorize more shares, you want to do something different, can you ever amend those documents? Of course you can. But now the thing was that you again have to make necessary filings, and it is possible that in order to amend the articles you need approval, right, of the board of directors, the shareholders. We'll talk much more about governance, but here, yes, if you're going to change the articles, you have to file the necessary paperwork with the state in which you are domestic incorporated. And real quickly, there's not a whole lot in this slide. All I really want to point out is that there are some corporations that want to be limited in what they do. And they will say we have a limited purpose. For example, a public corporation has a very limited purpose, right? I mean, if it's a water company, that's all it does. It can't say that we will set up, cable operations. That's not its governance. That's not what it's allowed to do under applicable law. So, but generally, most corporations will pick a general purpose goal. We will do, as a for-profit corporation, whatever we are legally able to do. So today we have all these conglomerates, right? I mean, you think about GE owning NBC, right? I mean, a company that we never thought would have operations relating to media. But yeah, I mean, corporations don't want to be limited in what they can or cannot do. They want to be able to buy and sell and expand and be as diversified as they possibly can. So most corporate clauses, when they file an article of incorporation, are going to be a general purpose clause, anything, right? And we've already talked about what a registered agent is place, a person that is named as someone who can accept service of process, meaning legal papers, on behalf of the corporation. That is a requirement under state laws. Bylaws. And the way I sort of explain bylaws is kind of like partnership agreements. Remember we said last class about you don't need a partnership agreement, but it's a good idea because you want to be able to say how are you going to run this business? Who does what? Do you get a salary? What kind of profits do you get? And who can run the management? Who cannot? I mean, what are the rules of this business? Right? That's not going to be in the Articles of Incorporation. It's going to be in a governing document referred to as the bylaws. Detailed set of rules. Adopted by whom? Adopted by the board of directors after the corporation is incorporated. How are we going to manage the business? Who are the corporate officers? How many? How many directors are we going to have? As we'll see in the next chapter, how many are we going to require to be inside versus outside directors? We'll explain what that is in a minute. Are we going to have a corporate seal? And this is sort of outdated. Used to be corporations had a particular seal that made them, Look, I mean, today's digital age, that means a lot less. It's very pretty. Thank you for making that point. Indeed, it has historical significance, but, yeah, it's something to think about. But today, it's more your trademark and that sort of thing, Yeah. And your digital presence, your social media presence more than, pen and paper. Yes, it got carbon paper and so on. I mean, all of us are dating ourselves, so let's not go there. Okay, so corporation has been incorporated, and the promoters are worried about their liability and so on and so forth. The first order of business is an organizational meeting, right? A meeting held by the initial board of directors, and there may be another sort of voting for the permanent board of directors after the Articles of Incorporation are filed. And, the directors are going to, remember we said formality in a corporation. Directors are now going to adopt the bylaws. They're going to elect the officers, and they're going to start conducting business in a formal way because most corporations, and by the way, it is possible, and I don't think this is on the slides, but it was in the book, that a company can decide, hey, we're small. It's the bar that you were talking about, Ron, that has one shareholder. They file their Articles of Incorporation. Are they doing all this? Electing a board? No, that's silliness. I mean, they're a corporation, but smaller corporations can elect to become what are referred to as statutory close corporation, meaning they don't have to do this formality. I mean, yes, what I'm describing are steps that a sizable corporation would do. But if we're talking about a corporation with 2 shareholders, or God forbid 1 shareholder, what are you going to do? Have a meeting with yourself? Name yourself? The CEO, the CFO, No. You will dispense of the corporate formalities. It is possible and very likely that small corporations don't do this. But any corporation of any legitimate size will go through this process of electing officers, adopting bylaws, and getting ready to conduct business. Yes?
What was the name of it? This one?
The statutory close corporation. Not on the exam, in the book, and an important concept. And that means doing away with corporate formalities and electing to run your business more like a small business, even though you get all the benefit of limited liability under a corporation. Okay, a few other things that have been sort of condensed into summary form on this slide. We haven't talked about taxation yet, right? We talked about limited liability, we talked about all kinds of things, but we didn't talk about taxes. And of course, we care about taxes. You guys are all future accountants. You really care about taxes, don't you? Yes, I'm hearing yes. So, corporations, generally, I refer to them as C corporation, not I refer to them, that's a term. C corporations are corporations that are subject to, dare I say, double taxation, which means that to the extent that the corporation is profitable, they will be taxed on those profits at the corporate tax rate. And then when that same money is distributed to shareholders, it will be taxed again at that individual shareholder's individual tax rate, right? So we all understand where that quote-unquote double taxation comes from. That's how it is. We always see, we have to bring down the corporate tax rate. Nobody says abolish the corporate tax rate. I mean, corporations are subject to double taxation. Well, how can you be a corporation and not be subject to that? Everyone raise your hand and tell me, it's right there. Become an S corporation. Right? What is an S corporation? An S corporation is a corporation that meets certain requirements. Not every Yahoo and Google can't say, we're S corps. You can. For example, to be an S corporation, you have to have a limited number of shareholders, 100 shareholders maximum. They have to be, a certain type of shareholders. You can't have more than one class of voting stock, on and on and on. No foreign investors, so it's limited. But it is possible for a business to incorporate, get the benefit of being a corporation, limited liability, become a statutory closed corporation, let go of the formalities, and elect to become an S corporation, and which means basically you will not be subject to double taxation. You will make a filing that you will not be taxed at the corporate level, only be taxed for federal income taxes based on the flow-through concept of when profits are distributed to shareholders, and kind of get the best of all worlds. It's a tactic that a lot of corporations elect if they can, or what a lot of businesses do is say, forget the corporation, we're going to be an LLC. Right? And a lot of times, as we'll talk about why an LLC versus an S corp, because it kind of give you the same benefit. Did I just take your question? See, you just have to let me talk, and I can just anticipate. Okay, that didn't come out right, but yeah, let me not trump you. Was that the question? Why would you? Let's just talk about it now since we're here. Primarily, the difference that comes to mind are FICA taxes. FICA taxes are those employee taxes that we withhold for Social Security and so on. And there, arguably could be a benefit to be an S corp versus an LLC. Again, it depends on your employee population and so on. But other than that, there isn't a huge difference between a smaller business that wants to set up either as an S corp or an LLC. In terms of attributes, pros and cons, they start to look pretty much alike. But remember, S corps have been around longer than limited liability companies have been, and in terms of the recognition, all of. So a lot of companies that were set up as S corporations are not. What's the point of changing? But you have to sort of look at each business, but the one big business, one big distinction that comes to mind are employment taxes, and sometimes they tip in favor of one or the other. But otherwise, not big differences. from a tax perspective, from a personal liability perspective, from a corporate formality perspective, and so on and so forth. Okay. The last three sort of rows here, express powers, implied powers, and got to have some Latin, ultra-virus acts, really talk about what a corporation can or cannot do, right? We talked about filing an Articles of Incorporation and basically saying, you could limit what a corporation can do, but generally speaking, corporations have certain powers. For example, they get these powers from laws, federal, state laws, bylaws, what they give themselves, the board over time adopting resolutions and so on. Those are express powers. We can do this, we cannot do that. But there might be certain things that even though you've never written down and you can't find a black and white notation anywhere, the corporation is just allowed to do. Pay their employees, open a bank account, things, those are implied. But the last one, an ultra-virus act, an act by a corporation that is beyond its express or implied powers. What happens if a corporation in its Articles of Incorporation file says our purpose is limited to this? And then the board, without amending the articles, does Y? Right? They have just violated the law. The law meaning they have violated what they said they couldn't do under their Articles of Incorporation. That kind of an act is an ultra-virus act. It's beyond the scope of what they are legally permitted to do. It's not that it's illegal, it's just that they couldn't do it. Or, what if it's a public corporation? Meaning a governmental corporation that goes beyond what the state authority gives them the right to do. I don't mean to pick on the Port Authority, but, what if? And again, that could have legal implications because that act may not be recognizable as something that the company or the corporation is legally. So remember ultra-virus. It is an unauthorized act by a corporation. Come on, everyone wants to know why Delaware, right? We all want to know. It's a teeny tiny little state. And yet, large banks, and why Delaware? So I've sort of put together a few bullet points that explain why Delaware. Well, surprisingly or not surprisingly, more than half of publicly traded companies in America are incorporated in Delaware. 60% of Fortune 500 companies. That's a lot. There are 49 other states, people. More than half. Why? A couple of big reasons. Number one, Delaware general corporation law, meaning the state statute, is the most advanced corporation law, most advanced. What do I mean by that? Advanced meaning it has, let me just sort of make the next point and then I'll explain. Delaware has a specific state court system that deals only with business law issues. It's called the Court of Chancery. Here's only business cases. The judges are very well respected because they just have, and here's where it comes about. Large corporations worry about mergers, corporate takeovers. We'll talk a lot about that. Understanding these, securities laws and not all states will have these advanced laws in terms of how a corporation can protect itself from a takeover. What kind of strategies can it put into its Articles of Incorporation? All of that has been. That's what I mean by the most advanced law. And what I mean by this court is that remember courts have precedents, right? Meaning what. Setting a precedent for what later cases. It's the most developed case law, meaning corporations know what they're getting into, know that it's going to be leading, cutting edge laws when it comes to business transactions, particularly mergers and acquisitions and shareholder rights and things like that. So that is why large corporations are attracted to a state like Delaware. Even though their corporate headquarters might be in the Silicon Valley in California, yet they would prefer to be incorporated in Delaware. Banks, for example, securities firms are very much attracted to Delaware for that reason. And I'll leave you with one little tidbit. What's the number 2 state? We're also well respected. Take a guess. Where did I hear New York? Very good. New York also has a very well-respected body of law, and so and just Why did you say South Dakota? Okay, it just sort of stuck out. North Carolina is being mentioned. I mean, off the top of my head, I can't think of, I'm not saying that other states are not sort of catching up, but Delaware, New York are the two big ones, yes.
Do a lot of banks go to Delaware because of their consumer laws?
That's another part of the reason, but remember, consumer laws are mostly federal, right? So yes, you may have, state laws don't necessarily govern, but that's part of it. It's part of it, but if you've got a commercial transaction happening with a consumer in Texas, I don't see how Delaware law is going to protect. It's going to be the federal laws that govern there. But maybe I'm not picking up that point as succinctly as I should. The major reasons why. And there, we could sit here and debate why Delaware for a long time and do research and so on. Major reason is it's really from a takeover perspective, from a corporate governance perspective, from a shareholder rights perspective, and the body of law that is so very settled, and the level of judges that serve on those courts are very well respected. So we're talking about, but if I just wanted to set up a small business, I wouldn't run to Delaware. These are not concerns that I have. I would go right here to New Jersey. But it's just that, so look at the statistics. Large publicly held corporations, 60% of Fortune 500 companies. So we're talking about big corporations, not smaller corporations running to Delaware or New York for that matter. All right, we're going to wrap up this chapter with financing, right? Because it's great to talk about all the laws and setting up and governance and so on. If you ain't got the money, you don't have a business, right? So how do you finance a business that is set up as a corporation? And we said, look, I mean, when you start with a very basic type of a business entity like a sole proprietorship, you're limited to where your funds are going to come from. It's going to come from the owner and the money that the owner is able to borrow. When you sort of try to expand into other more sophisticated business types like partnerships, general versus limited, you can attract investors and partners. But when you're talking about a corporation, if it's a smaller corporation, then you're still relying on owner individuals, shareholders, you're relying on borrowing and so on and so forth. But when you're talking about large publicly held corporation, and that's what we're going to start to shift gears toward when we talk about corporate governance and takeovers and so on in the next few chapters, we're talking about a corporation that is financed by equity, interest, and debt instruments, right? That's typically the case. And this is not a class in corporate financing, and we're not going to get into a lot of detail. We're just going to sort of cover the very, very peripheral, very sort of overview kind of issues. Well, when we're talking about equity, for the most part, we're talking about stock. Issuing stock ownership interest to shareholders. What kind of stock? The two big categories, of course, are common versus preferred, right? And the big difference being that common stock is usually without preference. What do you mean by preference? Well, preference meaning that with preferred stock, you might pay a bit more, you might get less voting rights and so on, but what you do often get is certain rights and preferences that common stock does not give you. So investors, as shareholders, when they invest in companies, look to see, well, what is my investment objective here, right? I want to own equity in a corporation because I want to perhaps get a dividend, I want to perhaps get appreciation, but to the extent that I want certain preferences, I look to see what kind of preferred stock this corporation might offer. For example, are they going to offer me a dividend preference, right? We know that dividends are not necessarily going to be issued with common stock, but with certain types of preferred stock, that might be something that is built into the ownership of that type of stock. For example, what happens if this corporation dissolves? If it dissolves, how am I going to pay it out? Well, it may be that creditors get paid first and common stock is at the bottom. But if I own a preferred stock with liquidation preference, I might get some priority with respect to getting paid out first, right? So again, these are things that from a corporate finance perspective, corporations are looking to issue different classes of stock to attract different types of investors. I'm going to not talk a lot more about the different types of preferences and so on. We're going to move on to types of shares. Right? We talked that in Articles of Incorporation, you have to declare how many shares are going to be issued. What's the upper limit? And you can pick an upper limit. You can change that upper limit. But you know, you have to sort of look to see, well, you know, when you talk about shares in a publicly held corporation, what does it mean to have authorized shares? What it means to have issued shares? What does it mean to have treasury stock? What are the number of outstanding shares, right? Because we're moving on to corporate governance, and we know that one of the things that shares represent to a shareholder is the ability to vote those shares. It's the ability to say that I get to have some voice in what the corporation does or does not do. So let's talk a little bit about what these terms mean. So authorized shares are simply the number of shares that a corporation is allowed to authorize, right? It could be, that's the upper number. You know, I'm just making up numbers. So if a corporation says we are authorizing 1 million shares, that's the upper limit. Okay, doesn't mean that we want to flood the market with that many shares, right? We may issue or sell far less than that over time. So the number of shares that are issued are the actual shares that have been sold by the corporation. So pick a number. Authorized million, the corporation at any given point in time has only issued 500,000 of those shares, right? Now you say, well, out of those 500,000, how many are shares that the corporation holds as treasury shares? And here the word treasury means the corporation owns those shares. And you might say, well, why does the corporation own those shares? Well, for a lot of different reasons. Sometimes, you know, again, corporation is giving away shares as compensation, restricted stock, and so on. Sometimes they want to keep those shares in their own name. For example, if they're a takeover target, they want to make sure that the company would vote those shares in their own interest and so on. So there are a lot of reasons why they would. The big thing is if the company owned those shares do not have a right to vote in terms of corporate governance. You don't go to a shareholders meeting and vote your own treasury shares, right? So they don't have those type of voting rights. But the shares that are out there in shareholder hands are referred to as outstanding shares, right? So those are basically, so let me just go with my example. 1 million shares authorized, 500,000 issued, and let's say the company has 100,000 in treasury. So how many shares are outstanding? Well, it's issued minus treasury. 500 minus 100,000 equals 400,000 stock shares that preferred, common, whatever, who has voting rights, have right to vote those shares at shareholder meetings and so on. So we'll talk a bit about that. So that's really what I want you to be familiar. What are authorized shares? What does it mean to have shares that are issued? What does it mean to be treasury shares? And what are outstanding shares? Simple. Simple. But again, terminology that I don't think should be foreign to you. I mean, for those of you that are taking other accounting classes and corporate taxes and so on and so forth, you understand this terminology. And again, we're not talking about in depth what debt instruments are, but just from an overview perspective, understand what debentures are, bonds are, and notes are. And real quickly, this is a great summary slide. What is a debenture? A debenture is a debt instrument, meaning it's not an equity instrument. It's sort of borrow, investors want different type of investments and equity versus debt instruments. What a debenture is basically a long-term, typically more than 5 years, a long-term debt instrument that is unsecured. Unsecured, meaning the corporation's general credit rating is what's behind that instrument. So, is that risky or less risky? It's risky. But along with risk comes the potential for bigger return. It's what an investor wants or doesn't want. So it's not going to be as highly rated because you don't have anything necessarily backing it except the general credit rating of a particular company. And we know that there are outfits like Moody's and others that rate those companies. What's a bond? A bond is also a longer-term debt security, but here you've got some sort of collateral, secured property that the company is putting behind it, again, might have a lower rate of return, but you're going to attract more investors because of the potential for more, quote unquote, safer investment in that type of an instrument. And what is a note? A note is basically a short term, your company wants to raise money quickly, it's going to issue a debt instrument, but that instrument matures relatively quickly, a year, couple of years, and so on, usually less than 5 years, and a note could be either secured or unsecured. And remember, a corporation is really engaging in all kinds of considerations when it decides whether to issue equity to raise money or debt to raise money, and if so, what kind of equity, preferred, common, what kind of debt, what are the corporate objectives, and so on and so forth. Our goal is just to understand the terminology behind all of this. Yes? Shareholders purchase, yes. Right, these are, right, ownership interests or debt instruments. So this is, out to the public. We're talking about publicly traded corporations. That's not to say insiders don't buy it. It's not to say corporate directors and officers don't buy the same thing. But this is, in the hands of individuals as owners of that company or debt owners of that company. Okay. The last couple of slides are on dissolution, termination, right? We've talked about it with partnerships as well. A business can end, does end. We talked about perpetual existence for the most part, but at some point businesses fold, and sometimes they fold voluntarily. I'm coming back to that bar example. If the owner of that business decides, I'm done, I made a lot of money, I'm now done, I will just close up business. Doesn't matter if it's a corporation, doesn't matter if it's a partnership, you are in that case voluntarily dissolving. You're deciding not to run that business anymore. And in doing so, if you're a corporation, you might have to take certain formal steps. You might have to file, just like you filed an Articles of Incorporation, you might have to file an Articles of Termination. And we'll see that dissolving the business means that you have to go through particular steps in terms of how you satisfy ongoing obligations. But a voluntary dissolution is the business owner or owners and shareholders decide to voluntarily wrap up the business. But sometimes the circumstances are not voluntary, but rather involuntary. And there are two types of dissolutions at the corporate level that are involuntary. Administrative, it's more detailed than I really care for everyone to know, but I want to just teach it. Administrative and judicial. And the difference here is that an administrative dissolution is where the state, where you're incorporated, says this business is not a legitimate business because they haven't met our requirements for continuing to be incorporated. For example, they haven't filed the necessary paperwork, they haven't maintained a registered agent, they don't pay their fees, and sometimes the business is just fizzling. There's nobody behind it that, so the state will say, we're going to give you notice, but we're dissolving you. You're no longer in existence. You're not someone that we're going to allow to operate because you're not meeting the state requirements for incorporation. Or what could happen is that the courts become involved. This is, again, in the event of a corporation of some size engaging in fraud or wrongdoing or things like that, it is possible that the state attorney general can bring charges against a corporation for abuse of authority, for fraud or something like that, and force that business into dissolution. Not to say that, the other side, you don't have due process or you don't fight it. You could, and you could be successful, but here this is really, really reserved for cases of fraud and wrongdoing and things like that. But in either case, once any business, including a corporation, is dissolved, we're talking, of course, about going through steps to, we talked about bankruptcy, of what happens when it's a Chapter 7 bankruptcy and you got to pay off, liquidate, and satisfy debts and obligations in a particular order. It's the same sort of thing. You have to satisfy creditors first, secured versus unsecured, then shareholders, depending on preferred versus common, and any other claimant, paying off your employees, paying off your 401k contributions, things like that. There's a particular order in which a business has to be liquidated, particularly a corporation. And again, to the extent that it is completely terminated, it might be a requirement that you then file the necessary paperwork in the same state in which the business was first incorporated, after the winding up, after the liquidation, after the distribution of the assets. Only one chapter, but a lot longer because a lot more detail. Yes? Sure. Yes. Winding up means once you are dissolving, whether it's voluntary or involuntary, but pre-termination. So it's the in-between phase. When you wind up is when you actually liquidate, pay off the creditors. So it's like it's a step-by-step process. Corporation no longer wants to be in business, for example. It's a voluntary dissolution. Well, once you make that determination, then what? Then you have to wind up the business, meaning you have to take the steps to dissolve, meaning you have to liquidate the assets, you have to pay off your creditors, you have to pay off your shareholders, and so on. And once you're wound up, once you've done all that, you are now terminated. Does that answer the question? Where are we? Last one. Right, winding, well, sometimes bullets are, liquidation is a part of winding up, I should say. Winding up is a process that includes liquidation, if that helps you understand it any better. Yeah, it is confusing, I agree. Other questions? And please ask if something is confusing. Yeah, I mean, it's sort of an informal term, but it also has legal meaning as well. Yeah. Winding up a business, yeah, it's used in statutes, it's used in case law, yeah.